Good evening, George Will here. Breaking news tonight from Beverly Hills, California, where a prominent luxury jeweler has filed a lawsuit in Los Angeles Superior Court seeking $890,000 in damages stemming from what court documents describe as the willful refusal to return borrowed jewelry items following a loan agreement that expired on September 15, 2024. The plaintiff in this action, identified as Maison Privée Beverly Hills, represents one of the most exclusive jewelry houses serving Hollywood elite, foreign dignitaries, and ultra high net worth individuals who require discretion, quality, and impeccable service. The defendant, identified in case number 24 CV 08847, filed on February 28, 2025, is Meghan Markle, Duchess of Sussex, who, according to the complaint, received on loan 14 separate jewelry pieces between March 2023 and June 2024 under agreements stipulating return within 90 days of each loan commencement date. The total insured value of the unreturned items as documented in the complaint equals $893,742, comprising custom diamond pieces, estate jewelry with historical provenance, and contemporary designs featuring rare gemstones including Burmese rubies, Colombian emeralds, and exceptional clarity diamonds. This is not celebrity gossip. This is not tabloid speculation. This represents a formal legal action filed in California Superior Court by a business entity seeking monetary damages and specific performance to recover property that was loaned in good faith under documented agreements and has not been returned despite multiple written demands. The complaint includes exhibits comprising signed loan agreements, photographic documentation of each piece provided, insurance appraisals establishing value, certified mail receipts proving demand letters were delivered, and communications from the defendant's representatives acknowledging receipt of demands but providing no substantive response regarding return. When a luxury jeweler with a reputation built over 3 decades serving the most discerning clientele in the world decides to file public litigation against a high-profile client, this decision reflects not impulsive action but rather exhaustion of every private remedy and calculation that reputational risk of litigation is exceeded by financial loss from non-return. What you are about to hear represents not only the specifics of this particular lawsuit, but a broader pattern of behavior involving borrowed items from designers, jewelers, and fashion houses that were provided for events, appearances, and photographic opportunities with explicit return agreements, but have never been returned despite contractual obligations and repeated demands. Because when someone builds a public image featuring luxury goods while possessing insufficient personal wealth to purchase such items outright, the fashion and jewelry industries traditionally accommodate this through loan agreements that provide access to prestige items in exchange for publicity value. But these arrangements depend absolutely on trust, and when that trust is violated through systematic non-return, the entire structure collapses. So, if you believe that contracts must be honored regardless of celebrity status, if you think that borrowing valuable property creates legal obligations that cannot be ignored, if you want to understand the detailed evidence before mainstream media sanitizes this into a billing dispute, you need to subscribe to this channel right now, because what follows is the comprehensive documentation that proves this is not misunderstanding, but rather calculated conversion of borrowed property into personal assets. The evidentiary foundation supporting this $890,000 lawsuit rests on 7 categories of documentation that collectively establish not merely failure to return, but willful conversion constituting theft under California civil law. First, we have the loan agreements themselves. The complaint attaches as Exhibit A through Exhibit N a total of 14 separate written agreements, each executed between Maison Privée Beverly Hills and representatives of Meghan Markle, authorizing temporary possession of specifically identified jewelry pieces for specifically identified purposes during specifically limited time periods. Each agreement follows a standard format developed by luxury goods insurers and employed throughout the high-end jewelry industry. The agreements identify the borrower by name, the specific pieces being loaned with detailed descriptions including carat weights, gemstone characteristics, metal content, and unique identifying features, the specific events or purposes for which the items may be worn, the insurance coverage carried by the lender, the requirement that the borrower maintain separate insurance during the loan period, and the specific return date by which the items must be returned to the lender's Beverly Hills location. These are not informal understandings. These are legally binding contracts containing all essential elements required under California contract law, including offer, acceptance, consideration in the form of publicity value exchanged for temporary possession, specificity regarding the subject matter, and explicit terms regarding duration and return obligations. Each agreement was signed by an authorized representative of the Duchess, specifically her business manager identified as Andrew Meyer of Sunshine Sachs Management Group, who possessed apparent authority to bind his principal to contractual obligations. Under basic agency law, when an authorized agent signs agreements on behalf of a principal, the principal is bound by those agreements as if she had signed them personally. Second, we have photographic evidence documenting that the borrowed items were in fact received and worn by the defendant. The complaint includes as exhibits numerous photographs from public events, media appearances, and social media posts showing Meghan Markle wearing jewelry pieces that match the exact descriptions contained in the loan agreements. These photographs are not merely similar items, but rather the identical pieces, as confirmed through gemological analysis of visible characteristics, including inclusion patterns in the diamonds, color zoning in the sapphires, and unique design elements in the settings. One particularly significant piece, a cushion-cut diamond pendant of 12.7 carats, set in platinum with a double halo of smaller diamonds totaling 3.2 carats, appears in photographs from three separate public appearances between April and August 2023. This piece alone carries an insured value of $247,000 and represents the single most valuable item included in the complaint. Third, we have insurance documentation establishing the replacement value of each loaned item. Maison Privé Beverly Hills maintains comprehensive insurance coverage through Lloyd's of London, specifically covering jewelry loans to high-profile individuals. Prior to each loan, the items were professionally appraised by independent gemologists certified by the Gemological Institute of America, photographed from multiple angles under standardized lighting conditions, and documented with detailed descriptions sufficient to identify the pieces if recovered following theft. These insurance appraisals, which are attached to the complaint as exhibits, establish not speculative value but actual replacement cost based on wholesale market prices for comparable pieces of equivalent quality and characteristics. The total insured value of $893,742 represents not inflated claims but documented replacement costs that Maison Privé would have to pay to recreate identical pieces if the originals cannot be recovered. Fourth, we have the demand letters sent via certified mail to multiple addresses associated with the defendant. California law requires that before filing conversion actions, the party claiming conversion must make clear demand for return of the property, providing the possessor with an opportunity to return the items and avoid litigation. Maison Privé sent its first demand letter on October 3, 2024, 18 days after the return deadline for the final loaned items had passed. This letter, sent via certified mail to the Montecito residence address, to the business management office address, and to the legal representation address on file, identified each of the 14 unreturned pieces, referenced the specific loan agreement under which each was provided, specified the return deadline that had passed, and demanded return within 14 days to avoid legal action. The certified mail receipts confirmed delivery to all three addresses on October 7, 2024. When no response was received and no items were returned, Maison Privé sent a second demand letter on October 25, 2024, this time indicating that failure to return the items within 7 days would result in the matter being referred to legal counsel for litigation. This second letter was again sent certified mail to all three addresses and was delivered on October 28th. On November 7th, exactly 7 days after delivery of the second demand, with no items returned and no substantive communication received, Maison Privé retained litigation counsel and authorized preparation of a complaint. A third and final demand was sent on November 20th by the retained attorney, providing one final opportunity to return the items and resolve the matter without court involvement. This attorney demand letter specified that failure to return the items by December 1st would result in immediate filing of litigation and that the lawsuit would include claims for conversion, breach of contract, and fraud. The certified mail receipt confirms delivery on November 22nd. No items were returned. No communication was received except a brief email from a representative stating that the matter was being reviewed by counsel, with no commitment to any particular resolution or timeline. Fifth, we have communications evidence showing that the defendant's representatives acknowledged the loan agreements and the outstanding return obligations but failed to take any action to return the items or explain their non-return. Email communications included as exhibits show that between October 2024 and January 2025, representatives of Meghan Markle sent multiple messages acknowledging receipt of the demand letters, confirming that the matter was being discussed with the Duchess, and promising that a response would be forthcoming. However, these messages contained no substantive explanation for why the items had not been returned, no assertion that the items had been lost or stolen, no claim that the loan agreements were invalid or unenforceable, and no offer to make payment in lieu of return. The pattern these communications reveal is one of delay and avoidance rather than good faith effort to resolve the dispute. Sixth, we have testimony from industry sources confirming that this is not an isolated incident, but rather part of a pattern involving multiple designers and jewelers from whom items were borrowed and never returned. While the Maison Privé lawsuit addresses only the 14 items loaned by that specific jeweler, sources within the luxury goods industry have confirmed to investigators that at least 6 other jewelry houses, 4 fashion designers, and 3 accessory makers have experienced similar situations where items loaned to Meghan Markle for events or appearances were not returned as agreed. These other businesses have not filed lawsuits, choosing instead to absorb the losses rather than face the public relations challenges and legal costs associated with suing a duchess. However, their experiences corroborate the allegation that the non-return of Maison Privé's items reflects not accident or oversight, but rather a systematic practice of treating loaned items as gifts or permanent acquisitions. Seventh, we have evidence of financial constraints that provide motive for converting borrowed luxury items rather than purchasing them outright or returning them and going without. Financial records obtained through discovery and other litigation matters have revealed that despite their high-profile lifestyle, Harry and Meghan face significant financial pressures, including a mortgage of $9.5 million on their Montecito residence, overhead costs for security, staff and property maintenance exceeding $700,000 annually, declining income from media ventures that have underperformed expectations, and substantial legal fees from multiple ongoing litigation matters. Under these financial circumstances, the temptation to retain borrowed jewelry worth nearly $900,000, rather than either purchasing it at cost or returning it and foregoing the status signaling it provides, becomes understandable as a motive even if not justifiable as conduct. Now let us examine the 8 categories of unreturned items that collectively constitute the $890,000 claim, understanding that each category represents not merely valuable jewelry but specific pieces with documented provenance, professional appraisals, and photographic evidence of possession. Category 1 comprises diamond jewelry, including the cushion-cut diamond pendant already mentioned at $247,000, emerald-cut diamond earrings valued at $178,000, a diamond tennis bracelet valued at $89,000, and a diamond cocktail ring valued at $143,000. These diamond pieces alone total $657,000, representing 73% of the total claim. Category 2 comprises colored gemstone jewelry, including a Burmese ruby and diamond ring valued at $74,000, a Colombian emerald pendant necklace valued at $63,000, and a sapphire and diamond bracelet valued at $51,000. These colored gemstone pieces total $188,000. Category 3 comprises estate jewelry with historical significance, including a Victorian-era brooch valued at $27,000 and an Art Deco platinum and diamond bracelet valued at $21,000. These estate pieces carry value beyond gemstone content due to historical provenance. The chronological timeline of this jewelry loan relationship reveals a pattern of escalating trust followed by systematic violation of contractual obligations that transformed a professional relationship into civil litigation. In March 2023, Maison Privé entered into its first loan agreement with representatives of Meghan Markle, providing the diamond tennis bracelet valued at $89,000 for wear at a charity gala in Los Angeles. The bracelet was returned on time as agreed, establishing initial trustworthiness. In April 2023, emboldened by the successful first transaction, Maison Privé provided the cushion-cut diamond pendant valued at $247,000 for the same event where it appeared in photographs. This piece was due for return 90 days later in July 2023 but was not returned. In May 2023, before the April loan's return date had arrived, a third loan agreement was executed for the emerald cut diamond earrings valued at $178,000. These were due for return in August 2023 but were not returned. In June 2023, representatives requested additional pieces for upcoming appearances, and based on the positive experience with the March loan that had been returned, Maison Privé provided the ruby and diamond ring, the emerald pendant necklace, and the sapphire and diamond bracelet under agreements requiring return in September 2023. None of these items were returned. In August 2023, when Maison Privé contacted the Duchess's representatives regarding the multiple items now overdue, they received assurances that all items would be returned shortly and that the delay resulted from the Duchess traveling extensively and the items being stored in different locations requiring coordination to gather and return. Based on these assurances, and in the context of an ongoing business relationship that Maison Privé hoped to preserve, no immediate legal action was taken. In September 2023, representatives again requested additional pieces, specifically the diamond cocktail ring and the Victorian brooch. Despite multiple items already being overdue, Maison Privé provided these items under agreements requiring return in December 2023, operating on continued assurances that all pieces would be returned together once the Duchess completed her travel schedule. In October 2023, Maison Privé provided the Art Deco bracelet for an appearance in New York. In November 2023 through March 2024, additional pieces were provided under similar agreements, each time with assurances that prior pieces would be returned. By June 2024, when the final loan agreement was executed, a total of 14 pieces had been provided, with only the initial March 2023 tennis bracelet having been returned as agreed. In July 2024, after the return deadline for multiple pieces had passed, Maison Privé began sending informal inquiries via email and phone calls requesting return. These inquiries were met with increasingly vague responses about scheduling and logistics. In August 2024, Maison Privé informed the representatives that no additional loans would be provided until all outstanding items were returned. In September 2024, as the return deadline for the final items approached with no prior items having been returned, Maison Privé sent a formal written notice via email demanding immediate return of all 14 pieces and indicating that failure to return by September 30th would result in legal action. September 30th passed with no items returned. On October 3rd, the first certified letter demand was sent, beginning the formal legal demand process described earlier. The legal consequences facing Meghan Markle from this lawsuit extend across multiple dimensions of civil liability, reputational damage, and criminal exposure. Under California Civil Code Section 1714, conversion of personal property creates liability for the full value of the converted property plus interest from the date of conversion and additional statutory damages. Conversion occurs when someone who has temporary authorized possession of another's property refuses to return it upon demand, effectively treating the property as their own and denying the rightful owner's superior claim. The 14 loan agreements established that Meghan Markle had only temporary authorized possession for limited purposes during limited time periods. The failure to return the items after the agreed periods expired and after multiple demands were made constitutes textbook conversion under California law. The damages Maison Privé seeks include the full replacement value of $893,742, prejudgment interest calculated at the statutory rate of 10% per annum from the date each item should have been returned, which adds approximately $112,000 to the claim, costs of suit including filing fees and service of process expenses and reasonable attorney fees. Under California law, prevailing parties in conversion actions are entitled to recover their attorney fees when the conversion was willful and malicious, which the complaint alleges based on the pattern of assurances followed by non-return and the failure to respond substantively to multiple demands. Beyond the monetary judgment, Maison Privé seeks specific performance requiring return of the actual jewelry pieces themselves. Even if Meghan Markle were willing to pay the monetary value, Maison Privé wants the specific items back because some pieces have historical provenance that makes them irreplaceable and because the jeweler's business reputation depends on its ability to protect and recover loaned inventory. If the items cannot be physically returned because they have been lost, sold, or otherwise disposed of, this inability to return strengthens the conversion claim and transforms the matter from a civil contract dispute into potential criminal theft. Under California Penal Code Section 484, theft occurs when someone who has been entrusted with property refuses to return it with the intent to permanently deprive the owner of its possession and beneficial use. When the value of the property exceeds $950, the offense constitutes grand theft, a felony punishable by imprisonment. While criminal prosecution would require district attorney involvement and proof beyond reasonable doubt rather than the preponderance of evidence standard applicable in civil cases, the existence of written loan agreements, documented demands for return, and systematic failure to return or explain creates a fact pattern that could support criminal charges if prosecutors determine that public interest warrants such action. The reputational consequences of this lawsuit extend far beyond the immediate parties and affect Meghan Markle's ability to maintain relationships with luxury brands, fashion houses, and the broader entertainment industry infrastructure that supports celebrity image management and public perception. When a jeweler of Maison Privé's stature files public litigation alleging systematic refusal to return borrowed items, every other luxury goods provider reassesses their willingness to loan items to this particular celebrity. The fashion industry operates on trust and reciprocity, with designers and jewelers providing items to celebrities in exchange for publicity value. When that trust is violated through non-return, the celebrity loses access to the pipeline of luxury goods that maintains their image, forcing them either to purchase items outright at costs they may not be able to sustain, or to appear at events without the jewelry and accessories that signal status and wealth. The scenario analysis for how this lawsuit resolves and what outcomes emerge from the civil litigation process reveals 5 possible distinct outcomes and pathways forward. Scenario 1 involves immediate settlement where Meghan Markle returns all 14 pieces without delay, pays accrued interest and legal costs totaling approximately $150,000, and signs a confidential settlement agreement that includes mutual non-disparagement provisions. This scenario would minimize public damage, restore the business relationship, and allow both parties to move forward. However, it requires that the items still exist in returnable condition and that Meghan Markle has the liquidity to pay the settlement costs. The probability of this scenario is approximately 15% because it requires prompt action and financial resources that may not be available. Scenario 2 involves negotiated settlement where some specific items are returned, payment is made for items that cannot be returned, and a structured payment plan addresses the balance over time. This scenario recognizes financial constraints while establishing a path toward resolution. The probability is approximately 30% because it provides face-saving compromise that addresses both parties' core interests while acknowledging practical limitations. Scenario 3 involves contested litigation where Meghan Markle files an official answer denying the allegations, claims the loan agreements were invalid or that the items were gifts rather than loans, and forces Maison Privé to prove its case through discovery and trial. This scenario would involve 18 to 24 months of litigation, significant legal fees for both parties, and extensive public attention. The probability is approximately 25% because while it allows Meghan Markle to fight the claims, the strength of the documentary evidence makes victory unlikely. Scenario 4 involves default judgment, where Meghan Markle fails to respond to the complaint within the required 30-day period, resulting in automatic judgment in favor of Maison Privé for the full amount claimed plus costs. This scenario would be devastating because it results in a nearly $1 million judgment without any opportunity to present defenses or negotiate resolution. The probability is approximately 20% because financial constraints and the distraction of multiple other legal matters might result in failure to retain counsel and respond timely. Scenario 5 involves aggressive counterclaims where Meghan Markle alleges that Maison Privé engaged in fraudulent inducement, that the items were defective or misrepresented, or that the jeweler's conduct constituted some form of actionable wrong justifying offset against the conversion claim. This scenario would complicate the litigation significantly, but requires factual support that likely does not exist. The probability is approximately 10%. The urgency of this situation intensifies because the 30-day deadline to respond to the complaint expires on March 30th, 2025, just 28 days from today. If no response is filed by that deadline, Maison Privée can immediately seek default judgment, obtain a writ of execution, and begin levying against bank accounts and real property to satisfy the judgment. The defendant must either retain counsel, file a response, and begin mounting a defense, or negotiate settlement before the default deadline passes. Every day that passes without action strengthens Maison Privée's position and weakens the defendant's negotiating leverage. So I want to know what you think. Type return if you believe Meghan Markle should immediately return all borrowed items and settle this lawsuit to preserve any remaining credibility. Type fight if you think she should contest these allegations and force the jeweler to prove every element in court. Type broke if you believe the real issue is that she cannot afford to purchase the items and cannot bear to return them given her financial situation. Your response tells me whether future investigations should examine other unreturned borrowed items from designers and brands, whether we should investigate the broader financial pressures driving this behavior, and whether you believe celebrities should be held to the same legal standards as everyone else regarding borrowed property, because this lawsuit is just the surface of a much deeper pattern. What we have examined tonight is one jeweler's experience with 14 specific pieces, but sources indicate that dozens of items from multiple luxury providers remain unreturned following similar loan agreements. The next investigation will examine the full scope of this systematic conversion of borrowed property, the financial pressures driving the behavior, and the broader question of whether someone living beyond their means while claiming victimhood and moral authority can maintain public credibility when they refuse to honor basic contractual obligations. Subscribe now and activate notifications because the evidence is mounting and the truth is emerging. I am George Will, and I will see you in the next investigation.